Great. Okay, so hello and good morning, everybody. Welcome to day 2 of the Legal Tech webinars. We look forward to keeping the innovation journey online alive through this series, and we hope you benefit from attending. I will now be handing over to Gideon Cohen, our moderator for the first panel of today. They will be discussing data and big data and litigation in light of the pandemic. Thank you.
Thank you very much, Jasmine. So I'll just give a very brief introduction with some thoughts, then I'll ask the panelists, our esteemed panel, to introduce themselves. And then we're going to get into some discussion points, hopefully get lots of feedback and thoughts from you guys listening in as well. So just by way of introduction, I am Gideon Cohen. I'm a co-founder of Solomonic, the litigation analytics company. And with my other hat on, I'm also a barrister at One Essex Court. There is an oddity in how most litigation decisions are currently made. These are, of course, often extremely financially consequential, high-stakes decisions. And yet we're still generally making them using a finger-in-the-air type approach, relying on gut instinct and often valiantly resisting putting numbers on how likely we think a given outcome might be. And also often failing to place advice or tactical decision-making in any kind of framework based on what's happened in similar situations in the past. That's pretty starkly at odds with just about any other form of high-level corporate decision-making you can think of. And indeed, you'll often hear corporate board members complain that litigation decisions are the only ones they're asked to take largely on faith, unmoored from data or any other empirically based reasoning. But there is, and we're going to be getting into discussing this shortly, a lot of relevant data to analyze on patterns of past claims, on different law firms, on experts or judges, on which parties tend to settle and which tend to fight. And all of this is likely to grow in importance as we see litigation starting to surge following COVID. So we as a panel are going to discuss some of those themes. And just before I introduce the first theme, I'll just ask our panelists to introduce themselves briefly, just so everybody knows who everybody is.
Hello, so I'm Lucinda Orr. I'm a partner at Enyo Law in London. We're a specialist disputes firm, and myself, I specialise in general commercial litigation in the Rolls building in London with the extra large trials.
Good morning, I'm Simon Mantell, the lead professional underwriter for QBE Insurance, also based in London. At QBE, we are the leading underwriter for solicitors in particular in England and Wales, but also leading underwriter of a number of professions across the globe.
Hello everyone, my name is Damien Honey. I'm a litigation partner at HFW in London. I primarily act on large commercial court disputes for clients generally based outside the UK who are using the brilliant commercial court that we have in London. So I'm really looking forward to this panel.
Good morning everyone, Nicholas Kronjager here. I'm Head of Legal Software Solutions for Thomson Reuters across the Middle East, Africa and Russia. And in my role, I'm helping law firms, corporates and governments to really get an understanding as to those data sources and software solutions that organisations have for litigation.
Excellent. Okay, thank you very much, everybody. And I should say, just as a reminder to anybody in the audience, you probably know already, but you can write in your questions. So we won't be doing the more traditional in-person asking for people to raise their hands, but we will be monitoring those questions as you send them in. Okay, so the first sort of subtopic we thought we'd tackle is headed educating ourselves and our clients on opportunities and risks. And to kick us off with that, we're going to turn to Lucinda.
Thanks very much. Well, firstly, we should probably establish exactly what we're talking about in terms of big data for lawyers. So what a Google analyst will think of as big data will be entirely different from a banking analyst to me as a lawyer. So big data originally associated with systematically extracting information from data sets that were too large or complex. But I like the fact that big data got too big for its own definition. and its current usage tends to be more about predictive analytics, which is obviously, as lawyers, what we're all more interested in, and how advanced data analytics methods can extract value from the data. So as lawyers, we need to know the sources of the data that will help us in advising our clients and setting the strategy for disputes. So, what is available in our toolkit. There used to be, databases of cases, and you would look at the LexisNexis or Westlaw and see if there were cases that had similar fact patterns to yours and what you could extract from that going forward. But now the products available to lawyers are getting very much more varied. So there's products like, the Lawyer's Litigation Tracker. So you can see how many days in court a certain law firm is having. Or you could, a tool like Gideon Solomonics, where you could now literally drill down to see how many times a particular judge has dealt with this particular type of case, and even go more nuanced that this particular judge always quotes from Chitty in their judgment, and therefore there's no point referencing Lewison on interpretation of contract, because you can already begin to read, you can gain some insight into the judge's kind of preferred text, and so you should be putting Chitty in your skeleton argument. And it's kind of that aggregation of marginal gains which may give you a competitive edge. So just as important about knowing where to find your data is how best to interpret it and deploy it. So they've said that data is big data is the new oil, but that quote, and very interestingly, you can see when it was first used in 2006 by the British data scientist Clive Humby, that everyone assumed he was just talking that that's where the new money is to be made. But the rest of his quote gets missed, which is that data is valuable, but if it's unrefined, it cannot really be used. It has to be changed into gas, plastics, chemicals to create a valuable entity that drives profitable activity, and it needs to be broken down and analyzed. So you don't just need the data, you need information to bring all that data together. Then you get into, if you have information, you don't just necessarily have data anymore, you need to put it into its narrative context. And that's when you get into intelligence taking the next step forward, and then you can use the information from that to drive your decisions. So I would see data as the kind of building block on which information, intelligence, and then decisions come from. So the good news for lawyers is that we can't entirely be replaced by data sets yet, and you still need to interpret the data that is being given, and so there is still value to be added in the disputes process. And one of those values is to be able to convince clients on the value of the data, and obviously databases are expensive, so you have to, as a law firm, for example, work out whether databases should be part of the costs of the firm, should be in the overhead, should be part of your offering, or it should be specifically billed to a client. So those are the kind of decisions that you need to make. And in a way that I think no law firm could now get away with not having access to things like LexisNexis or Westlaw for cases. And it's, possibly already you can predict the trend that there will come a time when analytical databases like Solomonics, for example, are the market norm, and essentially you have to have them. It has to be part of your offering as a lawyer. And so what are the opportunities then with big data for lawyers? Well, currently, if you are a lawyer and you're using it, you're probably at the vanguard. So you may be able to gain insight into a dispute and spot a trend, and therefore better advise your client and gain an advantage over the oppositions for not just in the dispute itself, but actually for winning the mandate in the first place. If you can go to a board when you're pitching and give them stats, as Gideon was saying, litigation doesn't rely on numbers very much, but boards always want to know what's the kind of percentage chance of success. If you've got some back data you can actually present to them, rather than saying, well, my experience is this, then that is very helpful. And possibly, in fact, the time frame on having the competitive advantage as a law firm for using data might be closing, because others will come forward and do it as well. So the equality of arms might begin to match up on it. But then, what are the risks? Well, there's three things to concern yourself with when you're looking at data, and obviously it's volume, variety, veracity. What was the sample size? Could something be skewing your results? Are there outliers that need to be discounted? You also kind of, in the Donna's Rumford world, you need to know what you don't know, what's missing from the data, what wasn't captured. Can you trust that data? And then, so you're back at data essentially being the first rung of the ladder, and it needs to be information and intelligence that build on it. So the risk for lawyers is taking the information, the data at its face value and not analysing properly. And lastly, and probably most importantly, data atrophies. Data is just a snapshot at that particular time. Situations change. So obviously we are now in COVID-19 and trends are going to be different. In the same way, if you were looking at the footfall in a shopping mall, you wouldn't just do July, August, September because everyone's on holiday, or you wouldn't do, November, December, January because that's when Christmas shopping is on and sales is going on. You need to take a wider, longer view. Now, the question with COVID is going to be, is it such a fundamental break that essentially it's going to be a reset button, and all the data we have on trends to this point are going to be obsolete, and we're going to have to start again. And ironically, obviously, eventually the data will tell us the answer to that, but not for a couple of years.
Great. Okay. Thank you very much, Lucinda. Really interesting. We've had a question in already. It may be that you sort of dealt with it actually in the last part of your comments there, but I'll read it anyway and see if you've got any further reflections on it. So the question's from Bernie Rivard, and he's asked, how will litigation decisions be adapted in the light of the new socioeconomic era we found ourselves in? Can we still rely on past data to accurately inform future outcomes? And I think that probably goes to what you were just speaking about in terms of being conscious of what might be skewing a data set or affecting a data set one way or the other. But anything you'd like to expand on in answering Bernie's question?
Well, I think currently, from 3 months of lockdown, it does seem to be that litigation is actually quite resilient, particularly in the English courts. They adapted very quickly to virtual hearings. And so from the kind of day-to-day running of litigation, it doesn't seem to be affecting it, or people have adapted to it. I think what's going to be interesting is as potentially clients might, the liquidity in the market might disappear. So if clients might want to spend less, there was obviously a concern that clients would just stop paying, but that hasn't happened either yet. But it depends how deep a recession and how quickly a V-shaped recession is, or how much scarring there is. So it may be that, for example, insurers have to take a certain line, because if they didn't on COVID, they would be bankrupt. So those are the kind of things where potentially we don't know yet, and the data in 2025 will tell how much of a break COVID-19 made to litigation generally.
Really, really interesting. Thank you. Thank you very much. I'd just like to invite our other panelists, if they have any thoughts, either on something specific that Lucinda said, or more generally on risks and opportunities in terms of using data.
Yeah, thanks, Gideon. I was actually going to ask Lucinda a question, if I may. And one of the first things you said was around the requirement to analyze the data. First of all, you've got the data in the first instance, and then how you go about analyzing that. Either at your own firm, Ennio, or any other firms you're aware of. Have you invested heavily in data analytics as a skill set, or are you encouraging your lawyers and partners to expand into that area themselves?
Well, this is actually one of the problems, that how do you educate lawyers and clients to understand the data themselves? For example, we do have some of the tools we paid for, things like Solomonics, and one of the problems I often had is associates trying to use it for something it's not designed for. So you need to also know the limitations of what the analytic tool can tell you. And I think there is no tool that can tell you everything. So it is actually about educating lawyers about where they can find the source that they particularly need, and then building them all together. So I would always say, look at, the case law, look at, Solomonics, look at litigation tracker and build a picture that way. So you're offering the complete kind of picture to a client. You're not just giving one kind of side of something, you're showing all the different faces.
Yeah, perhaps just picking up on that, and it depends on the type of data as well. I mean, we're certainly at HFW using it and encouraging all our lawyers to use it. But I mean, there's one stark example of data. So if you have an arbitration and you want to challenge it, let's say an LCIA arbitration, the only way you can challenge it is a Section 68 application under the Arbitration Act. And what data will tell you is that the percentage chance of success on a Section 68 is literally 1%. Because
yeah, it's very low, I know.
Very low. So if you present that to a board, is any board going to take that decision to pursue a Section 68 challenge, which could be very expensive if you've only got a 1% chance of doing it? Most lawyers will tell you on gut instinct that you've got a very poor chance of success on a 68, but it's possibly worth a go because it might have settlement value. That changes the debate around data, particularly for business people who are taking decisions with information which is real. And that's where it's going to be quite different. And I don't think COVID, to answer the question we've had, I don't think COVID is going to change that because the commercial courts are operating very, very effectively on Skype for business. It's a fascinating area.
Yeah, I think this is why it comes into the, when you use the data and then you have your information intelligence decision, and the data is always going to be the bottom part because there's always going to be other factors that need to be built on top of it. And so, as you say, there may be a business decision about why they want to make the Section 68 appeal, but even though they know that the percentage chance might be low, but there may be other factors that need to be. And as a lawyer, that's why I don't think data is going to, Gideon said about gut instinct, but I still think there is going to be value in experience of lawyers wrapped around the data. It's just one more thing you're bolting in to the offering, but it's not the dominant thing. I don't think it will become the dominant thing.
I think reputational issues are a very interesting example of where the data, there's a limit to the data because you might have a very important reason to fight a particular case, even if in pure financial terms, as perhaps revealed in part by the data, it doesn't make a lot of sense, but there could be other reasons why you think it's important to go ahead nonetheless. I mean, I suppose one question which occurs to me in this context is whether anybody thinks that the data might itself start to affect outcomes, if I can put it that way. So give an example, one of the things that Solomonic analyzes is how frequently different parties settle or fight cases. And is that just as one example, do the panelists see any prospect that data, I mean, not specifically that data point perhaps, but the data like that, whatever the source, may start to have an effect on people's thinking? People
so
may start to think, well, I don't want to appear. Yeah. Sorry, go on.
No, so it becomes a self-fulfilling prophecy. That the trouble is, if people look at the data and say, oh, well, this client always settles, and therefore they think it's going to settle, and therefore you kind of the data begins to drive kind of the new data in the sense that it kind of warps it in some way. So I think there is something to be said about like if you're for the Section 68 appeal point, there'll be less and less appeals because people think they're not going to be successful, so people won't try them. So the percentage goes down and down and down.
I think Gideon, a really good point there about reputational risks. So if I go back to the last time when, inquiries and discussions about tracking litigation outcomes, litigation spend and litigation data were at its highest, it was probably 2011, 2012. And that was based on the 2008, 2009 economic crash with most of the financial services clients that we had. So the biggest banks in the world were then in a position where they had to put a litigation management solution in place. Not just the contextual data about the judgments and the rulings, but there was huge reputational damage that was unfurling. At that time, you know, the figure was about $73 to $75 billion of legal spend, of which half was allocated to litigation, just on one of our solutions alone. That figure has risen over the last 7 years up to about $90 billion US dollars of spend, of which half, so $45 billion, is litigation allocated. So there's huge amounts of financial data associated with this, taking it from a slightly different angle here. But I think what's interesting to me as a non-lawyer is looking at this and almost questioning, well, once you move outside of large financial services, large real estate, large pharmaceutical litigation, is it just the rest of the world after that? You know, is it really litigation and analytics and spend that's only of interest to those big corporates because they continue to be implicated in those significant expenditures? I'd love to hear from Damien and Simon and Lucinda about that as well.
Absolutely. Anyone want to take that on?
Well, I think if I answer your last point first, if that makes sense, in terms of, do I think it's just a large corporate thing? No, frankly. From QBE standpoint, we have clients of all sizes, from one-man bands all the way up to, in lawyer terms, magic circle firms. And, you know, at any one stage or any given stage, any of them could find themselves in a litigation dispute. And I think the data and the decisions we make off the analysis of the data would ring true at any stage. Clearly, we'd have to analyze and look at the size. You're not going to use the information that happened in one particular case or on one particular client to directly inform you on something else, but it's going to give you a broad context. And I think if you start to chunk it up into the the subsectors of the various economies or parts of industry, then you can absolutely use that data and those decisions to inform you.
Yeah, I think. Well, sorry, go then.
Sorry, Lucy. I'm just going to quickly say, I think one of the issues will be a bit of an arms race with regard to data, because who has it available to them and who doesn't have it available to them, and is that going to create an unequal playing field, and is then the judiciary going to get a bit concerned about that because parties are being advantaged and disadvantaged? I mean, that's always been a bit of a debate in arbitration, which is of course confidential. So if you have a law firm that does a lot of arbitrations in a particular sector and then keeps records of all the decisions, that in some ways is big data. And then they're up against another law firm that isn't involved in that sector and doesn't have that information and can't have the information because it's confidential. That's the sort of the scenario I'm talking about. And is that fair, in inverted commas? I mean, that's some things, I think, where people's ability to spend to get the big data may start to cause a concern, and we may see, I don't know, regulation around it, but that's some way off, I think.
Yeah. And I was going to say, as an analogy, like the electronic trial bundles, for example, were the preserve of the very large cases for the last decade, as in only because the clients had to pay for them themselves, and essentially was only really kind of Opus 2 in the market in the UK and now globally. It wasn't cost effective for smaller cases to use it. One of the things that COVID has meant is that obviously even small scale trials are now happening virtually, and they have to have kind of tabbed PDFs, etc. And so the offering is kind of coming down on electronic trial bundles. And I can see the kind of, and I put it one in my kind of introduction, that the cost of big data, like there is a competitive advantage now to having it, but it may be that it has to become part of your offering. Like every law firm will have to have it in the same way that every law firm has to have, access to Lexis or Westlaw. You couldn't get away with not having that. And then, the question is, will it come down the cost in the market, essentially, that people like Stone & White can offer it for less because everyone has to have it?
Yeah, I think there was a really interesting point you mentioned early in your brief, Lucinda, which was about our database is expensive. And I think, certainly 10, 12 years ago, yeah, they were extremely expensive. Everything was deployed on premise. You needed a server, you needed an IT manager at least, or someone outsourced, which was even more expensive and time consuming. So are you seeing a difference there then, in that actually cost is reducing, that access to this information and technology is, less cost prohibitive?
Yeah, I think it is coming down. The cost is coming down, but for like big data stuff, this is and litigation analytics, it's still new in the UK market, and so I think it will take a while for that to come down. And one of the things to also consider is you can have too much data. You can be overwhelmed by it. You also need to select and kind of filter what is the most useful thing. There's always this kind of story about Chicago's medical. They would have people coming in and they'd give them like 20 pages to fill in, and they would say, you know, to try and diagnose what was wrong with them. And in fact, in the end, they worked out they could do it in 3 questions. That, you know, they could refine it down to that. And the same as with kind of big data, you don't want to be overwhelmed with it. Like, how much do you actually need to know to win this case? What is the acceptable level of spend for this case?
Okay, great. I think that could be a really good segue actually onto our next sort of segment, which is going to be led off by Nick. And the sort of headline we're giving this is this big data or something different? And if so, what? So if I hand over to Nick to introduce that topic.
Yeah, thank you, Gideon. I think between us all, we've already covered a lot of the points that I was going to make. It's made my job very easy for this introduction. But what I would say is that there are, if you look at industry standards, and I'm taking away from Thomson Reuters hat here and looking at IBM, IBM data scientists, you know, since 2019 have used the 4 V's analysis. So when they categorize this big data, which is volume, velocity, variety, and veracity. So I think if we look at volume, we are certainly into the terabytes of data when we look at this analysis. So documents, judgments, rulings, case, online legislation, and physical documents. The velocity part might be the hardest bit. I think the speed at which we're actually gathering this data, surfacing it, and making it consumable for our clients, suppliers, law firms, lawyers is not happening as quick as you may need it as a lawyer. And the variety, really, there are only a few key sources and collection points where we can find this data. Certainly, you know, I'm covering very unusual territories and organizations and regions in my job. Getting transparent information from Middle East, African and Russian organizations is incredibly difficult, including the central courts under which we operate. So if someone is, you know, asking me, well, can I get a artificial intelligence analysis of all the case judgments? Absolutely you can, but I've only got 3 case judgments that I can plug into that system. So how worthwhile is that actually going to be to you? So we're just doing a bit of myth busting here in terms of those buzzwords, AI, big data. But I do think we're at that point, crucially, within the US and the UK, where we do have the volume, velocity, and the variety. In terms of the uncertainty, the veracity of that data, certainly there are becoming some interesting patterns here, which we've already touched on, which is, you know, would I rather file something in a certain court based on the judgments of the judges and the arbitrators that work there? Absolutely. On a personal level, if I know that my planning permission on the house is going to get approved, I'm 100% going to file it there versus my other local court. So based on these insights, I definitely think that what we can categorize here is what we would classify some elements of it as being big data. And then I think from that, I touched on it earlier, but we've got those content providers like Solomonic that we mentioned earlier, and how they're able to surface that judgment data. That's fantastic. We've done that definition piece, but then I also think that we need to analyze the spend associated with that as well. So there is a financial implication of all of this data, whether it be external cost of outsourcing that work or internal human cost of having people review documents versus having a solution to do it for you. And lastly, you know, would human prediction outweigh a computer prediction on this activity? Well, I can tell you the computer normally wins on most of these tasks, whether it's digital proofreading, whether it's searching. The fact is we should be looking at the technology as our partner, as our friend within this process. It does need to be cost effective. We don't need to be prohibitive in the way that we can actually make this technology available to perhaps some of the most vulnerable people and organizations and regions that will need it the most. It shouldn't be just available to those large law firms and large corporate legal departments. So that's my summary, that's my introduction. As I mentioned before, coming at this very much from the technology angle of how do we tackle this, and happy to take any questions and interact with the panel further on this.
Fantastic. Thanks very much, Nick. Just to encourage, so audience, just a reminder, you can send in by writing any questions, and we will certainly deal with them as soon as you do. And in the meantime, are there anything from the other panel members to chime in on any of the points Nick's been discussing?
I was interested in what he was saying about kind of essentially black spots where data isn't available. So on the kind of the presume it was the kind of the courts in the Middle East example, and not having proper access. That is a problem if you're trying to look at something, if you haven't got complete picture, and you'll end up with skewed data.
Yeah, absolutely, Lucinda. I mean, some of the jurisdictions, you know, there are case publications that are made. There's often things that simply aren't put into the public domain. I think that has to be a societal shift, that has to be government-led, where there is full transparency and communication. And I'm picking and choosing my words carefully here. But ultimately, that's what's going to make that cultural change of, you know, we have had a case, it has had a reputational risk to that government or to a large government-owned entity or individual of that country. And as such, you need to make that information public. In the Middle East, we've had a number of initiatives to do that. The no one is above the law ruling that came in from Sheikh Mohammed. There's been other Dubai International Financial Center initiatives that have been run. But it still remains a challenge. I also have my colleagues in Kazakhstan and Russia, Kenya, Nairobi, Uganda, where getting access to the information is possible, but it takes so much time to actually gather that information, at which point often it's redundant. It may be 2 or 3 years old by that point. So I think we're fortunate in the United States and the United Kingdom that data is free to access at some point. But we need to also think about this from a global perspective, particularly as it relates to the current pandemic that we find ourselves in.
And can I ask then, Damien, because obviously you specialise in arbitration, do you see there's going to become a tension eventually with arbitration's secrecy?
Possibly, but equally, I think there's going to be a tension with neighbours, as we find between the UK and France, for example. Where France are not allowing data analytics, and I think there's going to be a big tension between, obviously the US and the UK are embracing it, but there's other jurisdictions which are not embracing it. Obviously arbitration cannot, unless it's a bilateral investment treaty dispute, which are all published so everyone knows about them. But again, it's good. I mean, I'm fascinated just in terms of how much lobbying, Nick, sort of the tech organisations doing to persuade, let's say, EU countries or some of the other governments that actually this is in their interest to do it. Because I certainly see the availability of data for certainly the English court system as a competitive advantage, which is obviously the dreaded word Brexit, is important in the current environment.
Yeah, I think there's been a number of good initiatives that we can run as an organisation ourselves, and you know, we shouldn't also get away from the fact that there will be an element of wanting to monetize that data, but that should be done very carefully. We need to remember at the end of this that access to justice and access to information is paramount to the success of why this technology works. But yes, I mean, we're fortunate in that regard that we do have people globally who can interact with, you know, judges, ministries of justice, to get access to that information, but it still does remain a challenge. I'm fascinated, Damien, that even between the UK and France there's an issue. I certainly wasn't aware of that, you know, having access to that data.
Yeah, the French have said no to data analytics because they don't want people looking at judges' judgments and analysing them, which seems, I think, a bit counterintuitive, because eventually I think they'll have to allow, because I think I don't really see, I know what they say the issue is with it, but I don't really see that they're going to be able to put up with that in long term.
Yeah, there's actually a prison sentence attached to anybody who does that work, which I think could give rise to some amusing conversations in the prison courtyard, asking, what are you in for?
That's up there with going to jail for cutting down your neighbour's tree. You know, that's that. You know, I would say that what will be interesting here is that technologists, hopefully like myself, will assist in the push of actually saying, well, look, this data will become public domain regardless of where you end up, whether that be through someone publicising it on social media incorrectly, which I know breaks the law, but the fact of the matter is that we know that these judgments and these hearings will, you know, often fall into the public domain. So for a judge's ruling to be plastered across Instagram or Twitter, which we've seen in a number of occasions, particularly with the Black Lives Matter movement, we're in uncharted territories and times on a lot of this data as well.
Nick, I wonder if you allow me to sort of change tack slightly. And first of all, I think we should probably congratulate ourselves for going 34 minutes without mentioning Brexit, but it was inevitable. In terms of sort of resetting the question that Gideon asked, which is this big data or something different? Would you say it's data or is it technology?
Combination of the two. So as I mentioned earlier, there are a number of fantastic solution platforms out there in the marketplace. And, you know, if I did have £1 for each time I was asked to implement an AI analytics tool into an organization which doesn't actually have access to that data, you know, I would be incredibly rich, but the technology wouldn't do anything. I'm taking this again from a slightly different tact here. I'm not just looking at English language documents, but for example, there's nothing that can analyze Arabic documents en masse at the moment. And there are thousands of Arabic judgment documents, as are there Russian, you know, so we've got different language, different character sets to consider here, even different directions of languages. So I do think that there is an ability for the solutions to provide insights, but again, that data does have to go through a cleansing exercise. There, you know, in tech terms, we always hear about GIGO, which is garbage in, garbage out. If I have one corrupt file, if I have one corrupt data set or row within that formatted database, everything will be redundant anyway by that point.
Yeah, that's a very apt way of putting it, I think. Okay, that's really, really interesting. Any other thoughts for anybody before we move on to the next subtopic?
I'd love to hear more from the panel about their adaptation. You know, I think certainly not for this group, but for many of the clients I'm engaging with, you know, Microsoft Teams, VPNs, Zoom, a huge shift in the way that you actually perform your day-to-day work. I can see we've all got nice backgrounds here of books and white walls, but often, you know, the reality is people are working in a chaotic environment. So what's the insight been from the panel on making that adaptation to a new way of working?
Well, I'll kick off from our side. I've been absolutely amazed, if I'm going to be honest, at how easily and how readily people have adapted. I think, you know, it sounds like a lot of other industries, but and indeed clients, we were very fortunate in having invested heavily in agile working capability and facility probably only 18 months ago. So if this had happened 2 years ago, we'd be in a very different position and a very difficult position, frankly. But as it stands, you know, I've been amazed with how easily and how readily people have been able to conduct 99% of their work remotely. You know, even some of the, you know, these face-to-face things have actually happened probably more straightforward. Everyone's got, there's more availability of people, there's more time without commuting. There are probably fewer extraneous and ancillary meetings that are taking up time in people's diaries and in people's lives, not least because there's no social life to be had and very few people are on holiday. So from that standpoint, as I said, you know, I can't underestimate how surprised I've been at the adaptability of both systems, technology, and more importantly, people to continue carrying on their day-to-day life, frankly.
I think from a lawyer's perspective, law was an easy one to translate to home working, particularly if everybody is home working. Most law firms had the tech set up sufficiently anyway, because there was quite a lot of kind of laptops, flexible working. So I agree, I never worked from home, and I thought I would be bad at it. And actually, in our firm, productivity is up 23%, which the senior partner is delighted by. But that's because I keep telling him that people have got nothing else to do, and that long term it's not sustainable like that. I'm actually in the office today because I needed to go to the Rolls building for something in person, and the city is dead. So there's a question about things coming back, and is this now going to be a fundamental shift for lawyers? But I'd be interested, particularly from Gideon, because I've had quite a number of virtual hearings now, but I haven't been the advocate for them. And I find them incredibly draining, much more draining than being in court. And so I don't think long-term virtual hearings are going to particularly for the kind of work I do, which, I've got a 3-month trial starting in October, and the prospect of doing over 50 days, 6 hours a day in front of a computer screen, I'm not looking forward to at all. And so I'm pushing for it to be socially distanced.
Yeah, I think that is, I haven't actually done any yet, but I think that is the consensus. People talk about Zoom fatigue. I don't know if there's a sort of medical or scientific basis for that, or if it's just people reporting their experience, but it's certainly, either way, it seems to be a real thing. And I think we're already seeing that courts are having to build in, rest days and things, or feel they have to, and as are arbitrations, actually, in ways that would never be conceived of for in-person hearings. I think the other thing that comes up is, because people from all over the world are often tuning into remote hearings, there is a need sometimes to feel that the hours need to be made more accommodating. Whereas if there's an in-person hearing, then obviously there's very much a focus on just what's most convenient for the people who are actually physically there. But yeah, it's certainly an interesting thought. I mean, an interesting point. One thought I have is the extent to which something like data can actually plug into an online hearing in some ways more easily than if you're in person. The ability we have to say, right, I'm on my screen here, but I can quickly open my screen there, probably something we tend to do rather more if we're doing things remotely than in person. But as you say, if, as I think is inevitable, we do move back to in-person hearings, that point may be diminished or may go away altogether.
I think we can expand on it as well. Again, coming back to the, accessibility of, getting to a courtroom, getting to a hearing. I think about people with disabilities, physical, mental impairments, who may be requested to be part of a judgment, and actually you're giving them an environment where it's much safer or much more familiar, where you can give people that virtual access to that information. So I think that presents in itself an exciting opportunity. I really do hope, as a technologist, that we don't all go back to working in the office 100% of the time. I do feel that, that 23% productivity gain, it could be balanced out around 10-15 once people do regain their social lives and start to move around a bit. But certainly, a big internal memo went round, which was less time on planes, and I think that is a fantastic way to look at this. More time with families, more time doing the important work that you need to, and hopefully being happier and healthier about it as well. We've got to think about the people behind it at the end of all of this.
Absolutely.
I mean, that's a good point around less time on planes. I mean, I spent 3 months a year on, traveling to go and see clients, and obviously that stopped. But what is quite interesting is the time zones differences for virtual hearings. I had a colleague who was doing a hearing in the Caymans, who's based in Hong Kong. So he was doing Cayman hours in Hong Kong, which was horrible. But equally, if we have a London commercial court hearing, witnesses in Asia, do they need to travel over to give evidence? I mean, there's a view that actually there is nothing that can beat an in-person evidence giving cross-examination, where you get to see the person giving evidence, and it's what they don't say, what you see, which matters for the judge as much as what they do say. So yeah, it's going to be fascinating to see how things change, I think, in the future. And we're not going to go back to what it was before, but I suspect there'll be quite a few of us still going back into the office.
Yeah, it's one of the reasons kind of for Zoom fatigue apparently is because it's much harder to read people on screen and your brain is having to work harder. And then for cross-examination through video link, all the kind of silks I've spoken to don't like doing it because it's much harder to read your witness. You can't see their, their hands, for example, or their feet. Their feet might be like tapping, very nervously or something. But if you'd see that in court, but they can be a swan on their screen, on their face bit. And it's also, you can't get the flow that you can get if you're cross-examining someone in person. You've got the time delay, it doesn't matter how fast your broadband is, it's not going to be perfect. And so I think there is something to be said for in-person hearings still, but lots of, all my clients travel, and one of the things we've got to decide is how many people come from which jurisdictions, etc. And is it worth it? If you're only giving half an hour of evidence, it's probably not worth you turning up from Moscow. But if you're giving 4 days of evidence, it probably is.
Yeah. So maybe from what you say, the witnesses will lobby to keep things virtual if they can. Okay.
Possibly not, Gideon, on one of the hearings that I dialed into, where I couldn't help but feel the QC was far more adversarial over the Zoom call than they would have been in person. Now, I can't say I've watched that person in person, but it certainly felt like it was, almost not quite, and I hate to use this phrase, keyboard warrior-like, because you are, you're there face to face, but it did feel that lack of barrier allowed you to be slightly more demanding, more challenging than perhaps if you were staring someone directly in the face. But anyway, that was my thought.
Simon, are you suggesting that QCs might actually be online trolls in their spare time?
Absolutely not. Absolutely not.
I'm sure not. Okay, well, perhaps if we could move on then, actually to Simon, just to talk a little bit about the next topic we have on our list, which is really from a corporate perspective, is how data can help insurers and other corporates. So, we've talked a bit about from a legal perspective, technology perspective, really interesting to hear it sort of more of a corporate and specifically an insurer-based perspective.
Yeah, thanks, Gideon. And it's a relatively broad topic to lead on, and I think we've addressed so far this morning already, but it is helpful, and it's to the extent of how helpful that I'm going to try and get into. But at its most fundamental level, if you allow me to start with insurers, as you said, data is the foundation, frankly, from an insurance standpoint. And if you start at the most basic concept of whether insurers choose to invest capital in a particular product line or area, they are unlikely to do so without at least some data to inform their decisions. That then moves on in terms of risk selection and indeed pricing. How do insurers go about pricing for the potential exposure and indeed which clients do they want to invest their capital in. None of that is possible without at least some data. I'll come on to whether this is simple data or big data in a moment, but data in its purest form is absolutely fundamental. And indeed, it's to a certain extent the availability of that data that can make the difference between success and failure for insurers in particular. As I said, without the data, it's a leap into the unknown, and the downsides can be particularly painful. And insurers have found that to their cost in numerous product lines and on numerous occasions. Within the insurance industry, the access and the use of data varies considerably. If we consider a moment the personal lines arena, such as your car insurance or your household contents, firstly, there is a plethora of historic claim and policy data that is used, almost to the micro level. Every single one of those infinitesimal questions that you have to answer is used at some point to assess your risk and your exposure. That is then overlaid with some of the, the big data that I've alluded to in terms of socioeconomic or political to a certain extent data. And then they've elaborated and advanced further now with the advent of smart boxes in cars, which track drivers' behavior, which helps further define the individual risk. So this is really, it's a heavily evolved part of the industry. If you then compare that to the commercial world where I sit in, it's miles behind. I mean, we use very simple data, partly because we don't have access to the more broader big data, but equally we haven't yet taken the time to invest either time or money. But you know, it's something that I think each insurer has had on their radar for probably a decade, but there's always, you know, the somewhat archaic nature of the industry has held it back for whatever reason, and people have been able to deliver against their objectives, and as such, they've not necessarily pushed forward in that investment. Certainly at QBE, we've set up a particular arm to invest heavily in this area, to work out how we can do things differently to ensure that we are at the vanguard, as what I said, in terms of using data, apart from anything, to improve the customer journey. You know, there's an element to it which is around ensuring we select the right risks in the first place and we price them adequately, but equally, what can we do to improve the customer journey through the use of data? Does that mean moving away from the continual filling in of online or paper forms, to allow almost a rolling informed basis through the use of online information, through the use of data? So there's a huge amount that we can do, and frankly, if we don't do it, there will be disruptors who are ready to come in and do things differently. So there's almost a requirement, a necessity, that we disrupt from the inside and look at doing things differently, rather than harking back to the sort of 19th century way of managing and rating on risk. If I just touch on professional indemnity for a moment, which is my area of expertise, and try and bring it back to the topic of the day around litigation, we really need to try and understand better what the data is telling us around the cost and the propensity for litigation. And that means mining every source that we have to educate us around these things. So Solomonic is a great example of that. But what else is available? What else can we use to try and understand that? Because ultimately that's going to be the be all and end all of whether we deliver against our objectives at the end of the day, whether we have charged the right clients the right price for the risk that they take. And that's a very difficult thing to do without data and without access to more broader data. So we, as I said, we're investing heavily. We're continually looking at new areas that we can lean on to provide that information, to improve and educate us and indeed our clients against the potential exposures. I guess if I step outside the realm of insurers for a moment, I mean, big data can provide all manner of information around customers' behaviour, not just in terms of their propensity to litigate, but equally when it comes to billings and the like, which customers are more or less likely to be open to a cross-sell opportunity within your firms, which customers are going to be likely or potentially likely to be late with their billings, which customers are likely to ask for a discount or reduction in their fees. So all these other things that are going to be fundamental to your businesses in terms of your ability to attract and retain clients, and in order to effectively manage your own budgets, data is absolutely fundamental to each and every aspect of that. I mean, that's without even getting into marketing, and marketing is basically a data-led exercise, which I think we're probably going to go miles off topic, but it just is an example of how fundamental data is to I think to all corporates, frankly, at every aspect and every facet of their business.
Thanks very much, Simon. If I could follow up actually with a question. At the very beginning of the session, in introducing it, I sort of asserted that there was a big difference in the corporate world between litigation decisions, which traditionally have been made largely without data, and other decisions. I'm just curious, is that something people agree? You first, I guess, agree, disagree? Any kind of further thoughts on that line, on why I might be wrong or right, or whichever way around?
If you just repeat the, I think I broke up slightly.
Sorry, just to say, is it right to say that there is a significant distinction between high stakes decisions in general that corporates, insurers or otherwise are being asked to make, on the one hand, and litigation decisions, those key points in litigation about what one's going to do traditionally, on the other hand, in terms of the role that data has been able to play, at least historically. Is that something where you really do feel that difference, or perhaps are there other areas which are not yet as data informed as one might expect?
That's a good question, and I think it was Nicholas, or perhaps it was Lucinda, who said at the outset, management of large corporates will always use data to inform their decision making. But yet when it comes to litigation, perhaps that data isn't used in quite the same extent, and yet you're having to make decisions at a significant financial level without that information. It's hard to say whether there are any, or I can't think of off the top of my head of any areas or other areas or decision making that is done without that same level of data analytics or analysis. If you were to looking to invest or move to another new territory, you would be undertaking all manner of investigation, and that is going to include data around, what's the customer base, what are the costs, what are, everything to do with cross-border transactions. But yet under the litigation, you are, to a certain extent, you're reliant on your advisors, and it's, whether the advisors have undertaken that analysis and can they articulate that analysis to you, it is the real difference, I guess.
Yeah, very, very interesting. I wonder if other panel members have any thoughts on that. And again, anybody in any of the other attendees, feel free to write in thoughts or questions on that theme. But perhaps other panelists, anybody want to chime in on that theme? I know we've got lots of different perspectives in terms of the direction people are looking at litigation from.
Yeah, Simon, I'm interested, knowing enough about insurance, and particularly the analysts and the level of expertise you have, for example, in an actuary who can run very complex statistical analysis and modelling. Have they been pulled in at all into the legal department, into the litigation area, to run that kind of activity or analysis of your data?
It's a one-word answer, and it's no, unfortunately. And it's something that has been raised, as you say. We have a huge number of data scientists, not just actuaries, but other professional data scientists as such. And as I said, they've been heavily focused on the pricing. We do analysis around the propensity to claim and how we can try and use the data to guide the ability to settle. But I guess it's slightly different from getting really into the litigation. It's more about before you get there, in terms of how we can prevent litigation happening, frankly. Can we buy things off at the early outset? And there are evidence of the timing in the year and the timing within the month as to when you make an offer to settle that can limit the downside propensity. So it's a yes and a no. I was probably being a bit too blasé with a no at the outset in terms of what the end state of the litigation, but certainly from a claims standpoint, yeah, absolutely. There's an awful lot of data analysis goes on.
Okay, well, I guess that to the extent that there are fields yet to be explored, that should be a source of excitement for us, I guess, as well. Okay, any other thoughts, comments from the panel? I mean, either on insurance or perhaps for those who are perhaps less involved in the insurance world, just corporates and corporate decision making around litigation more generally.
Just on the insurance, I was always interested in kind of how insurance may drive a decision, like whether to litigate or not, or whether to settle at what point, because it becomes a monetary. You reach a point on a graph where the spend is greater than the kind of the recovery, and therefore it settles, and therefore potentially kind of pieces of litigation with important legal points don't get heard because essentially the insurance market decides to settle the case, and how that can warp precedent.
It's a good introduction. I'm not sure I have an answer necessarily, but you're absolutely right. Insurers will always be looking at the financial implications, perhaps above the ability to make good law. Whether that's right or wrong is a difficult quandary. you know, I have at least an example of one of our clients where we were able to support them in litigation in order to make good law. So it's not always, you know, trying to buy off the risk, but you know, inevitably it's going to form part of the conversation and part of the analysis as to whether it's worth it.
Yeah, I mean, certainly my experience is, let's look at reinsurance, for example, where sometimes decisions are taken to pursue it because a particular clause in a standard form contract is uncertain, and actually there's much more material benefit to getting certainty on that clause for the business than just that one claim. But yes, I can see that. That's quite interesting. I'm just going to pick up one point, which is the role of funding now in and essentially big business in litigation. And that is really starting to have a material change because to the way decisions are taken. Because if you were investing a 2 million, 3 million, 4 million pounds into a claim, it's a pure business decision. There's no emotion around it at all. And that's where we've certainly seen big data starting to have an impact and making a real difference. I don't know if the other panelists have seen that as well.
Yeah, I was in fact had been thinking about we should be mentioning funding because I do think it changes the landscape on litigation when people obviously have now got a financial stake in it without any of the kind of emotions attached to it, and it also it plays into the point I was making about insurance because it also becomes a kind of a pure financial decision about when to settle or how to settle or when to continue, and so I think and presumably, and Gideon can answer this, that the funders in particular must be very keen on the data and getting as much accurate data as possible.
Yeah, I think they without revealing any confidences, I think funders certainly are very interested in the data that's available. I guess for broadly similar reasons that, say, an ATE insurer might be interested, or indeed not that different from anybody with a financial interest in the outcome of litigation. I guess the difference with funders, as was being pointed out, is that all they have, I think Damien's saying, all they have is a financial interest in the outcome of litigation. I suppose unless they have a portfolio of claims, and then they might actually be not that dissimilar from a corporate entity in thinking about some of the wider ramifications. But it's absolutely true that's right. And I think the other point there is obviously settlement does become even more paramount because from a purely financial perspective, nobody really is gaining. Even if you end up winning at court, you might well find that if you could have obtained a very favorable settlement, you would have been better off. So the data that exists on what happens to claims when and by whom they're settled, I think is of particular interest. And I think that it's probably also important in thinking about the skewing of samples, as somebody was saying before. If we're only looking at that relatively small proportion of claims that actually make it all the way through the funnel and come out with a judgment at the other side, then we probably are missing a bit of context in thinking about, well, what's the wider universe of claims that we ought to be tracking and monitoring, so that we have a better sense of what happens to different kinds of claims involving different parties.
I think that's fascinating, Gideon, particularly about the claims. If you look at claims that may have been started and then actually either withdrawn or settled early, certainly those withdrawn claims, I'm sure for Simon as an insurer, would give you indication as to possible false claims as well. But it's a fascinating time that we live in with access to all of this data and trying to make sense of it all. I'm interested as well, though, to know more about how you foresee your roles, everyone on the panel, how you foresee your roles, as human beings in all of this, because there's still a human element required within court and being a lawyer. As much as I would love and think it would be great to do everything online, I'd certainly rather be able to pick up the phone to one of you to ask you a question than have to go through a chatbot and automated response, which might be wrong.
Yeah, I think there's a risk that you see litigation as like a pure science or with pure data points. It's still human, and it's still got humans involved. So I've done cases where the ability of the lawyer or the kind of quirk of the judge has made the difference. So it's not like AI where they will, if you put in the data, you'll get the answer at the end. There is all these other factors. So litigation is still an art. It's not a pure science.
And law changes as well. And I mean a good example.
It's organic.
Yeah, is the concept of good faith in contract law. English law's never really understood it, but now we have a Supreme Court judge who is if you look at some of his previous judgments, does promote it. Is that going to change? Now AI can't really. That's not predictable. It's going to depend, and that's what law brings to it. It is evolving, it is changing, it is developing with society. So I can't see the human element is ever going to be taken out of it. It's certainly going to make us a lot more efficient, I think.
I think insurance underwriters were one of the highest professions that is most likely to be usurped by computers. So I think I'll probably retrain as a data scientist anyway.
What I was going to say, I think there's flex. That law needs to flex to society, and COVID-19 has shown that that the laws get brought in. It's flexible, and therefore you can't predict necessarily because the law reflects society and the times that are changing. So the data is always going to be a snapshot from before. So that's why you still need humans to interpret it, and people want to have their judgments given by people. They don't want it given by a computer.
Yeah, and I think all I was going to say, I think it may go back a little bit to actually what Lucinda was talking about a while ago, which is, what are the risks and limitations? I think it's not just a question of saying, here's a risk, therefore let's not use data. It may be a question of saying, here's a risk or a limitation, which should make us use data in a different way or in a more cautious way. So, for example, to say, here's an individual human being who's the decision maker, I can't trust a computer to spit out an answer as to what that person's going to do with huge accuracy. What I can do is say, let me look at all the decisions that human being has made in the past and break those down and structure those and see what I can pull out of that might help me to think about how one deals with that person as a decision maker. So I think in some cases it's a matter of, it's not so much a binary, either the computer can give one the answer or it can't.
Oh, the
I think we may have
computer's
lost
turned him
Gillian.
off.
No, I could just say that for example, in New York, they did a trial with AI for bail applications and against reoffending. And the AI computer was much better than judges were at whether people were going to reoffend. But if you asked people, did they want their decision by a computer AI or a judge, everybody wanted a judge to make their decision for them.
Yeah. I wonder what the analysis would be if you went one level further than that and said to the people that had been, so you the computer's answer, which is you're not going to reoffend. You tell the offender, well, the computer says you're not going to reoffend. I wonder if that would have any decision. Yeah. But I think what's interesting, so certainly insurance, financial services, huge data sets as well as looking at things like sports performance analysis. That was one of the first industries which actually used human behavioral metrics to analyze, how likely is it that someone's going to have an injury, that someone is going to have a prolonged career or a short career. So it's interesting to see that throughout that process, and we're talking about technologies that are 15 to 20 years of age now, there has always remained a human element involved in that process. There is still a sporting director, there is still a head of athletics who makes those and manages those decisions as well. So hopefully technology enabled, not replaced.
And it's obviously still free will on humans, as in if you're told you're not going to reoffend, does that mean that you think you're not going to reoffend, so you don't reoffend?
Yeah. Then we get into theory of knowledge, I think.
Indeed, probably slightly beyond the scope for today, but an interesting one if we get into epistemology nonetheless. Sorry, I got cut off before. I think I'd probably spoken for too long in any event. I wonder if we could move on then to, I see we have a question here, which perhaps we'll come to, but I wonder if, just before we come to that question, if we could ask Damien, who's going to lead off on our last topic, and then we will come to the question from which we've got from the audience. But if I could ask Damien to lead off on analysing the litigation history of particular parties, firms, claims, and judges.
Thanks, Gideon. And I think I'm going to speak for a short period of time, 2 minutes, 3 minutes, just to focus on how practically big data can help, and certainly the way that we've seen it helping and informing decision-making processes. So firstly, clients doing sort of client litigation peer reviews. And these are clients who are active litigators. So they're not one-off litigators, they're pretty active litigators, often in particular sectors. So for example, the energy sector. And what we have seen is some clients wanting to peer review their litigation performance to some of their competitors and to see, well, what's our win rates in the litigation? What's our lose rates? When do we, if we settle, when do we settle? And how does that compare with some of our peer companies? And this is particularly the case for some clients who perhaps perceive, rightly or wrongly, that they have a reputation in the market for being weak or hard or soft. So if they have a reputation in the market for being a weak litigant, they'll commence proceedings but never pursue them. Is that reflected in the data? And that's been absolutely fascinating, having those conversations with clients, with us having the benefit of having the data available, just to get them thinking about strategy. And it's nothing to do with a particular case. It's all to do with how the psychology of their corporate entity approaches litigation and what they use it for. And having that data set to say, well, actually, you have only succeeded in 43% of all the cases that have gone to trial, starts to make them think, well, why is that? But equally then understanding that actually you settle 80% of your cases. So you issue a claim form, but it never actually gets to a trial. And then they compare that to some of their peers who have a higher win rate or a lower settlement rate. And that is really helpful in informing decisions. And the second thing that we have seen it being used for, and this is either a good thing or a bad thing from a law firm's perspective, but certainly an interesting thing from a client's perspective, is what are the, if you're a claimant and you've got a big case, you're pushing out an RFP to work out which law firm you're going to instruct. What people actually have not looked at in the past is they've based it on gut. You know, this is a good firm to go to. But now actually, if you have a firm who's relatively active, let's say before the commercial court in London, you can check if you're a claimant, their win rate. And to work out whether that matters for the purposes of informing your decision-making process as to which firm to instruct or not instruct in a big dispute. And again, that's it's just pure data. And there could be many, many reasons why that law firm has got perhaps a lower win rate. They may have advised the client that it wasn't going to succeed, but the client decided to pursue the case anyway and lost. So it doesn't take those factors into account, but it provides a data point which businesses, we're certainly seeing, are finding quite interesting to rely upon, because it does provide some rational credibility to a decision-making process. And then the final point, which I know others have touched upon, and this is when I think it starts to become concerning for some people, is analysis of tribunals. And I use tribunal, it could be a 3-person court of appeal, it could be a 5-person Supreme Court, it could just be one single judge. And you analyse the decisions of those judges on particular points to reach a view as to what the outcome is going to be, to give some form of predictability about it. And it's becoming concerning for some people because there are views that would say, well, ultimately, if you get a judge selected who you know is particularly always going to find on a particular way on a particular clause in a particular contract, you might try and get the trial adjourned to try and ensure you get a better selection of a judge at a point in the future. Equally, in any court or tribunal, that's the case. I mean, certainly the English system, you just get allocated a judge relatively close to the trial, so it's often quite difficult to do that. But I know that that's been a bit of a concern, let's say in France, for example, where ultimately people then try and game the system, which is not fair when the data is being used. And I'll give you one example, and this is an example from an arbitration context in a bilateral investment treaty dispute. There's certainly an arbitrator who is always chosen by states as to arbitrate particular disputes, because she or has a reputation for, if you analyse her decisions, if you look at the data, you can possibly work out which way it might go, which way it might not go. Equally, that you could do that for particular judges if they are deciding a particular clause in a particular contract all the time. There's a nervousness around that, but it's certainly what the data is starting to provide, and the more data that comes forward, the better availability of statistics it creates. But law firms need to be using that and are already using it. So that's just sort of three areas I thought where actually the data is now making a real practical difference and influencing decisions.
If I could just follow up.
Thank you very much. Yeah. I was just going to say, any other panelists want to chime in on that? Lucinda?
Yeah, just following up. The UK, obviously, we don't generally docket our judges. So you will find out very late normally, and your judge might not even be the judge who heard your pre-trial review. Whereas I clerked in the United States and have done quite a lot of work there. And obviously there you are, the judge carries all the way through. So there is quite a lot of difference, I think, in UK analytics versus the US analytics, because you don't know who your judge is going to be. So there's still a level of unpredictability. And one of the things that is coming out with the analysis is that there are quite wide variations actually on judges inside, the Chancery Division or the Commercial Division. So as kind of lawyers, how do you think we can do you think that makes it less easy for us to use the data than, say, our American counterparts can? Because we won't know till last minute who our judge is.
I think you're right, Lucinda. I think it does make it more difficult. Although sometimes in the commercial court, they are trying to move a little bit to having judges allocated from the case management conference. So there is that approach, certainly for larger cases, starting to be applied. But I do think it's certainly at the present time, it's much more useful data in the US than it is in the UK because of that late minute allocation.
Yeah, I think in the UK, just to add to that, it may be partly a question of knowing what the risk is. Your judge will be one of 15 people. Who are the outliers? What do we have to be aware of in terms of who we might get, even before we know, as lawyers, who we're going to get? Any other thoughts on that sort of theme from other panel members?
I was just going to sort of continue that conversation, and presumably, whilst you don't know a particular judge or a particular set of judges, that propensity, if there is an outlier or the one or two outliers, comes into the percentage of risk, presumably, in terms of how you ascertain the likelihood of success or otherwise. Obviously, if you did take away that one data point, then it goes to the one of the V's that Nicholas was talking about in terms of variety or whatever it is. You can take that out and it becomes a more or a better estimate, but presumably even without that, you can still apply some element of probability to success or otherwise.
Absolutely. And it goes back to Gideon's point before, is that if you have a case, you're probably of a view, knowing the bench of potential judges that you can get, that you'll be thinking, well, I really hope that this case doesn't go before X, because we know what X might think of this case because of experience. And so, yes, ideally you would know what you would want to know, And you can do some analysis because you can then work out, so in the commercial court, a number of judges will be on circuit or not available because they've been allocated to long-term trials. So you can narrow the choices down, but you're absolutely right. It will factor into the advice that you're giving. And that's been the change, really, because often you would, as a lawyer, you would just analyze the law and give a view. But now what you have to do is do that, but then actually give a view on the basis of, you then look at the panel of judges who might be available. That can be tricky because if you're giving the advice at the start of a case, you might not reach trial until 18 months later, by which time the panel could look very different. So it does depend what time you do it, but it's absolutely something that is taken into account now.
I think it's easier to do for when you're deciding which division to start in, whether you should start a case in, say, Chancery, commercial, business lists, etc. I think that is now becoming easier to do because you can analyse, well, Chancery is more likely to find this way than the commercial court, which previously had just been on kind of gut instinct or people's preferences, but now you can actually look at the data on it.
Yeah.
Just chiming in there, we've had one question from an audience member about, perhaps particularly for the lawyers on the panel, although I'm sure anybody could chime in, about combining being a data scientist and being a lawyer. What do we think the potential is for data scientist lawyer hybrids, as it were, in the future?
Well, actually, I think one of the things that a lot of my junior lawyers get most upset about is that they actually have to learn a lot of tech as well now. To be a lawyer, you can't just, it's not just block letter law. There is a lot more you need to give as a package to your client. So you need to know how to use all the platforms. You need to know how to kind of analyze data. And so actually, you know, it's not about being a data scientist and a lawyer. Lawyers are having to become much more rounded anyway. You know, it's not just that, you need to be a project manager. For the large scale litigation is project management as well. There's a whole load of skill sets that you now need to be a lawyer, which I think maybe 25 years ago you didn't need. And in, you know, now what we've been discussing today, how to kind of analyze the data is now a skill set that lawyers are going to have. So whereas you previously needed to know how to analyze the law, you now need to also know how to analyze the data to overlay on the law.
Yeah, I think interestingly enough, and to carry on from that point, thankfully, I don't think you need to be experts in both, definitely one or the other, depending on what your job title is. But I think you need to understand enough effectively to be informed, but also to ensure that if you are going to bring technology into your legal department, your firm, your chambers, that you are aware of the limitations and the possibilities of it. I'm not saying you need to understand the code behind that application, but you certainly need to understand enough about the key concepts. So a couple of resources, I would definitely learn any kind of database querying language. So Microsoft SQL being the most prevalent. You can learn a lot about that through Microsoft Access and free online resources. Fantastic ways to just get that fundamental understanding of how a database works, and then from that build on it as you will. If you can become that lethal combination of both, then I think the future looks very good for your firm or your partnership.
And I think, I mean, just to answer the question as well, I mean, law firms are now employing a vast range of different people, not just lawyers, and becoming much more similar to sort of the consultancy businesses in terms of the way they approach their business, and data scientists are being employed by law firms to work alongside lawyers. And finding someone who can do both would be fantastic. Absolutely brilliant, and absolutely what is going to be needed over the next 10, 15, 20 years. I mean, certainly some of the junior lawyers sort of are worried that, like a lot of people these days, their job's going to be taken away from them because of AI. I mean, ultimately, it's not in my view, but there's going to have to be a significant upskilling of everyone, including the seniors in the business, around tech, and actually having those skill sets are exactly what law firms are looking for.
Yeah, so just to throw in then a couple of questions from the audience on slightly different topics, but as we're moving to the end, I thought I'd just ask them both and let anybody chip in on either or both. So one question is about how all this compares, what we're talking about here, to the continental civil system where judges change at every stage during litigation. How can the variety of judges play a role in this discussion? And the other question, I suppose, and what we were just talking about now is on the role of legal project managers and whether that adds value in this context as well. And so I guess anybody who wants to chip in on either or both of those questions.
I'll just chip in on the civil law question and the inquisitorial approach as opposed to the adversarial approach. I think it's more difficult, the use of data in those systems, because of that very reason is that you do get different judges and therefore the predictability is not there. Equally, availability of decisions as well to analyse is not, as we've seen with France, is not there. And there's also often some jurisdictions, for example, like Switzerland, where you have a very diverse system of the cantons, again, makes it quite difficult as well. So I think it's going to find more favour in those large places. I would say it's Hong Kong, Singapore, DIFC, AGGM, those types of more common law courts, I think, where there's a panel of judges selected and sitting on it, so you know which judges are going to be. I mean, I haven't looked at Germany, for example. It'd be fascinating to see whether that would work in Germany, particularly at the most higher court level, where you're likely to have a panel of potential judges that you could, well, who would only be available to give decisions.
I'm reminded that we're coming, thanks very much, Damon. I'm reminded we're coming towards the end of the time now, so I guess just any final thoughts, either on those questions we've just mentioned or more generally from any of the panelists before we wrap up?
To answer the person who's asked about legal project managers and a role within law firms and whether it adds value to client, I think it depends on the law firm structure and the kind of cases that are being run. I think there is, as Damien was saying, there's definitely many more kind of bolt-ons into law firms now, be it, you know, intelligence or reputational management or legal practice. So that there is role for legal project managers within firms, but it depends on the firm and the kind of work that it does. One of the things we found at our firm, though, you know, we didn't need an IT manager anymore, because actually all the associates had upskilled sufficiently, or because, you know, they're millennials and they knew enough that in fact that kind of role became obsolete within the firm. So when he left, we never replaced him, and it hasn't actually made any difference. We now use external consultants if we need it, and that's better value for the client.
Yeah, and final thought from me, just saw a question about what junior lawyers should be learning in terms of software systems. Depending on where you are in your life, I would go and speak to the people in the IT department, make them your best friends, understand what technology they use, because they will be approachable to tell you about what's being in place. But typically, if we take this from a law firm angle, there will be a practice management system, which is the golden source for everything that happens within the organization. So familiarize yourself with that. There'll probably be a document management system as well, alongside the typical Microsoft Office applications that you use. In chambers and in smaller mid-sized law firms and corporates, you will see a tremendous amount of different technologies utilized. Good old-fashioned Microsoft Excel is, you know, one of our favorites, but also you will see at the higher end of corporate legal departments where they'll be using SAP, Oracle, SharePoint, industry standard applications that have been customized to legal tech as well.
Thank you very much. I think that's a great point on which to close, as I see we've reached the top of the hour. So thank you very much to all of the panelists. I imagine we can't do the usual round of applause at this stage, but we can imagine virtual applause for our panelists. Have all made fantastic contributions. Thank you very, very much. And thanks everybody in the audience as well for listening and for all of the wonderful questions as well. And enjoy the rest of your days.
Thank you, everyone.
Thank you very much.
Big thank you to our panelists and our moderator, Gideon. I think that was a really wonderful conversation, and we could have gone on for, I'm sure it could have gone on for a lot longer. Yeah, I'd just like to say we have another panel running, Legal Skills of the Future, at 1:30 today. If you're registered already, then I look forward to seeing you there. However, if you are not and you still wish to do so, you can still do so via our website. The links are all still working. So thank you very much, everyone, for attending. Again, thank you to our panelists, and hope to see you soon. Bye, everyone. Thank you.
Thanks. Bye. Bye.